Now, in order to do this, he structured his opinion this way. He asked three questions. He asked, did Marbury have a right to his commission? If he had it, and if that right was violated, do the laws of the United States afford him a remedy? And if they do, was that remedy a writ of mandamus from the Supreme Court? Now, in response to the first question, Marshall argued that yes, Marbury did have a right to the commission. He said the commission was completed when signed by the President and sealed by the Secretary of State. To withhold that commission, the Chief Justice concluded, violates a right. Well, then do the laws afford a remedy to Mr. Marbury? And again, the answer was yes. Chief Justice Marshall wrote that the United States was a government of laws and not of men, and that liberty required that vested rights be protected. Well, this led to the third question, was that remedy a writ of mandamus from the Supreme Court? Marshall held that it wasn't. Now, you might think Marshall would say yes in order to help his Federalist buddies. If the Supreme Court issued that writ of mandamus, Marbury would receive his commission, his appointment. But instead, Marshall went for the gold. He selectively quoted Section 13 of the Judiciary Act of 1789, which granted the power to issue writs of mandamus, and then he misquoted and mispunctuated the Constitution to conclude that Section 13 and the Constitution were in conflict. Now, why did he do this? Well, he did it so he could raise the following question. He asked, and I'm quoting here, can an act repugnant to the Constitution become the law of the land? In other words, he sidestepped the mandamus question and raised a whole new one. And he did this to create a conflict between a congressional law and the Constitution, and to ask what to do when there's such a conflict. Now remember, the Constitution doesn't say who gets to decide if a congressional law is in conflict with the Constitution. What Marshall then did was to claim that the court had the power to resolve these conflicts. And this is the power of judicial review. It's the power of a court to declare invalid acts of the other branches on the ground that they conflict with the Constitution. Now, politically, judicial review furthered the power of the Federalists. Why? Because it strengthened the central government. A court, a Supreme Court with the power of judicial review, could invalidate state legislation. Now, what were Marshall's arguments in favor of judicial review? Well, he had three main ones, and they revolved around the supremacy of the Constitution and the role of the Supreme Court. The first one really stems from the notion of fundamental law. And here Marshall wrote that the Constitution controls any legislative act repugnant to it. Otherwise, he said, why bother have a Constitution? Why write it down if it's not going to have any impact and effect? Second, he made a claim about a broad view of judicial review. In the most famous language from the opinion, Marshall wrote, it is emphatically the province and duty of the judicial department to say what the law is. And this was because he argued if the court can't strike down an act of Congress, then the Congress in effect can subvert the Constitution. The Congress can do whatever it wants. There'd be no limited government. If the court didn't have the power of judicial review, the legislature would be supreme, and this would deny the supremacy of the Constitution. Third, he made an argument from the oath. That is to say, justices of the Supreme Court take an oath swearing to uphold the Constitution. Why, Chief Justice Marshall asked, would they be required to do this if they couldn't follow the Constitution and strike down laws that were repugnant to it? The oath would be meaningless. So the conclusion was Section 13 of the Judiciary Act of 1789 was unconstitutional, and the Supreme Court had the power to declare it so. Now, critics have had a field day with this opinion. I want to highlight some of their major points. One is that Section 13 is clearly not unconstitutional. By toying with the Constitution, Marshall was able to bend it to his will. Second, it's argued that Marshall's arguments for judicial review are weak. Marshall argued, for example, that the Constitution is a supreme law. That's fine, critics say, but it begs the question of who decides if it's been violated. Why does the Supreme Court have the power to invalidate acts of Congress? Why is the reading of the justices of the Supreme Court any better than the reading by Congress of what the Constitution means? Second, Marshall argues that if the Supreme Court can't strike down a law as unconstitutional, Congress can subvert the Constitution by doing anything it wants. But critics reply, you can just reverse that. If the Supreme Court strikes down laws, it can subvert the Constitution as well by doing anything it wants. Further, to strengthen this position, people point out that Congress has political safeguards. Think about it. The Congress is divided between a House and the Senate, and both have to agree if a law is to be enacted. There's the veto power of the president. And perhaps most importantly, members of Congress have to stand for re-election. If the people don't like what they're doing, they can throw them out of office. In contrast, the court is not politically accountable. There are no safeguards on it. Third, Marshall argues that Supreme Court justices swear an oath to uphold the Constitution. Critics respond, but all federal officials take an oath supporting the Constitution. Why is the oath more binding on the justices of the Supreme Court than on other governmental officials? Now, fourth, Marshall's arguments ignore the problem of why such an enormous power as judicial review is not expressly stated in the Constitution. As a Pennsylvania judge put it, the grant of a power so extraordinary ought to appear so plain. Where in the Constitution, he asked, are we to find this proud preeminence of the Supreme Court? Now, while the decision was legally weak, it was politically brilliant. It won points for the Federalists by criticizing Jefferson for mistreating Marbury. It strengthened the central government by asserting the power of judicial review, and it avoided counterattack by issuing no order that President Jefferson could disobey. After all, Marbury lost the case. He didn't get his commission, and the decision was self-effacing. It claimed that Congress was giving the Supreme Court too much power, namely the writ of mandamus. In the process, Marshall was able to create the power of judicial review. Now, perhaps because of Marshall's political skills, the reaction to the decision mostly ignored the issue of judicial review. Instead, it focused on the asserted judicial right to examine some executive acts, in this case, the acts of Secretary of State James Madison. But Jefferson understood what Marshall was up to. In a letter to Abigail Adams in 1804, he wrote, and I'm quoting here, "The opinion which gives to the judges the right to decide what laws are constitutional and what not would make the judiciary a despotic branch." Jefferson won the battle, but he lost the war. Now, modern-day supporters of judicial review make better arguments for it. And they essentially focus on the fact that judges are not democratically accountable. What they say is judges have life tenure. The Constitution says they're there on good behavior. Their salaries can't be lowered, and most importantly, they don't have to stand for re-election. Why is this a virtue? It's a virtue because it means they can withstand the prejudice and the partisan political pressures and public opinion better than most other officials. It means they can protect unpopular minorities and rights when they are threatened. Now, the Supreme Court refrained from using its asserted power of judicial review to invalidate a congressional act for another 54 years until 1857. What is most remarkable about the Marbury case, though, is the weakness of the argument. It is worth pondering what it means that the court's most important power is based on such a weak foundation.